All right, so in our last mini lecture, we talked about kind of in general what is a retirement plan, and different forms of it, whether it's IRA or 401k. The form of it doesn't really matter. In general, they're taxed for income tax purposes pretty similar. You can defer the income tax while it's inside the wrapper of the retirement asset, but once it starts to come out, and there is a mandatory time when it starts to have to come out, you start to pay income tax on those distributions. And importantly, we talked about the beneficiary of the retirement plan, regardless of the form of the plan, is governed by a beneficiary form similar to a life insurance policy or retirement asset. Then the next big question becomes how do we mold that retirement plan into our estate plan, which is oftentimes in the form of a will or a revocable trust document. Doesn't really matter the form you use. But we know a will only governs probate assets that the decedent owned in his or her name, and a rev trust only governs assets that the trust either owns prior to death, or assets that are directed to the trust at death via a so-called pour-over will. And the beneficiary form of a retirement asset trumps both of those things. And just as a recap moment, we also briefly talked about on the last mini lecture that naming the estate, quote unquote, the estate as beneficiary, while it will in fact direct those retirement assets to the will to be governed by the will, is not the best way to do it because of the 5-year rule when an estate is named as beneficiary of a retirement asset. So how do you get the retirement asset over to the plan? And this diagram is not unfamiliar to you. We've talked about it a lot in class. We've got our will. The estate is where the assets go. They funnel through the will. The first trust over here is what we've been calling the credit trust. It has a cap. It will fit a finite number. It will fit that tax exempt amount, 11.5 roughly. And then we've talked about any excess flowing over here to the marital share. We've talked about anything from marital outright to marital in trust, the most common trust being the Q-tip trust. So general, this is kind of what we spent a lot of time in our class drawing up on the board. So sometimes when you're trying to fill up this bucket right here at the first death, and we're kind of putting portability to the side for a moment, but we know when we've got a large estate, whatever that means, roughly 25, 30, $40 million combined net worth between husband and wife, and we're not going to rely on portability, and we're trying to fill up this bucket. We've talked about making sure the decedent who dies first, his or her assets flow into here first, making sure there's 11 million to flow, 11.5 to flow into this branch right here, and these will be protected from estate tax. It could be from here on out, depending on how you've drafted this, but certainly they won't be in the estate of the second spouse to die, so long as this is drafted correctly. No general power of appointments, nothing to include it in the surviving spouse's estate. We know this part will be, because it's marital deduction, and all the marital deduction does is defer the tax, not avoid it. But how we land the retirement assets is really dependent on the beneficiary form for those assets. And just like life insurance, our beneficiary form really will probably, for the IRA or 401k, will give us two choices: a primary beneficiary and a secondary beneficiary. And you guys know from doing your internet research on the Secure Act earlier this week that there are some real benefits to naming a spouse as beneficiary of retirement assets. They're like the gold medal level of beneficiaries. The so-called stretched payout, instead of the finite number of years that the Secure Act gives us, and I'm intentionally not saying that number because I want you all to find that number in your internet research this week. But what you probably are finding is a spouse gets some real benefits as being named as beneficiary. Not only can they possibly stretch out taking the distributions over time longer, so they're taking less into income over a longer period of time, minimizing their income tax hit. But a spouse also gets a rollover option. They can either start taking the benefits and start paying tax on it, or they can roll over the retirement assets into his or her retirement account and keep deferring the income tax on it until the retirement plan rules say you have to start taking it out. We're not getting into what those rules are. But the point is, a surviving spouse has a lot of options, more options than any other beneficiary of a retirement asset. So a common plan that you will sometimes see is on the beneficiary form, if we want to preserve the ability for the spouse to have those options, rolling it over, taking out assets over a longer period of time, it's not uncommon for the spouse to be named as primary beneficiary of the retirement plan. That makes a couple assumptions, presumptions when you're doing that. It takes into account that the decedent, the plan participant, is fully trusting the surviving spouse to do with the retirement assets what he or she wants done. So the decedent knows that his surviving spouse is going to use the retirement assets, and then the leftovers are going to go where the decedent, the first spouse to die, likely wanted them to go. Because when you roll them over to the surviving spouse, he or she fills out a new beneficiary form and names beneficiaries there. So last spouse to die really governs where those assets go. Works arguably fine in a first marriage situation where you've got joint kids and everybody has the same plan for the kids. Arguably might not work so well in a second marriage situation where you're both bringing kids into the relationship, because the second spouse to die might have different intentions of where those leftover retirement assets go. So push those issues to the side for the moment. When you don't have some of those issues, giving your surviving spouse the ability to be the beneficiary and enjoy the benefits that come with it is sometimes pretty key, which is why you'll see him or her named as primary beneficiary. But there may come a situation where after the first spouse to die is gone, because you're filling out these beneficiary forms in 2020. Right now you're filling them out with your client. Hopefully you're not going to lose your client for a while, and so you're implementing it in 2030 or 2035 or sometime later. And if your client that passes away has this will, and the spouse is named as primary beneficiary, the retirement assets never become a part of this scheme right here. And maybe you want them to when death time comes around in 2030 or 2035. Maybe you want a second chance to direct those retirement assets to one of these buckets. And that is going to be driven primarily by tax laws. If there's been a change in the tax law where it makes more sense for those retirement assets to land in primarily this bucket versus this one, but to land in this bucket versus a surviving spouse outright, how do you get it there when you filled out the beneficiary form 15 years ago? Well, there is a way to get it there, and it goes back to disclaimer planning that we've talked about. We know from disclaimer planning that if you follow certain rules, and you got to know what those are, to do a valid disclaimer, then the recipient of that property who is doing the disclaiming is treated as deceased. And so the assets will then go, well, where does the plan send them next if the intended recipient is deceased? On this type of form, the intended recipient is the spouse. The secondary beneficiary is there in case the spouse is not here. So if the spouse is alive and well and disclaims those assets to send it to the secondary beneficiary, because that's where it'll go. I mean, we know from disclaimer rules that if a beneficiary disclaims, you either look to what the document says next, who takes it if he or she disclaims, or if there is no document, you look at intestacy, or if there's a beneficiary form and the primary beneficiary disclaims, where does the beneficiary form send it next? Uh, this type of beneficiary form can give you a second bite of the apple to send it to one of these buckets under the will. Whether and most times you're going to do disclaimer planning that might have this trust as secondary. Um, Most times it's this because you're disclaiming for tax reasons. And so that's what I want you to take away from this. I want you to take away what is a retirement plan, and we kind of went through that in the last mini lecture. How are they governed as part of your estate plan? The beneficiary form trumps. There are typically some default rules if you don't fill out a beneficiary form, which a lot of folks don't. They might fill one out and then move employers and forget to fill it out at the new one. They might change investment brokers and have it filled out fine when they're at Merrill Lynch, but then they move over to A.G. Edwards and they forget to fill out a new beneficiary form. So knowing the default rules, which most times is the participant's estate, which will in fact send it through the will, but at a cost. You've got to take it out over 5 years, typically. Or giving yourself a little bit of flexibility, naming your spouse as primary beneficiary and all the benefits that come with that, rollover opportunities, and extended payout opportunities, and then keeping a secondary beneficiary on there. One, you need one anyhow in case a spouse is deceased, but having a strategic secondary beneficiary on there that will allow the surviving spouse to disclaim the assets and let the secondary beneficiary take over if that's what makes sense at the time. The time could be 5 years later, 15 years later, it could be 1 year later, but just giving yourself some options with that later. You don't want to ignore the issues that come along with second marriages and blended families and the importance of thinking through the beneficiary form there. We're not really talking about that right now. That's what I want you to take away from these 2 mini lectures. And it's really just a survey of the introductory components of doing your estate plan and making sure you incorporate the retirement assets. Because the perfectly drafted will or rev trust without more is not going to incorporate what sometimes is the biggest asset. All right, we'll stop there for right now.